Information Station 1370 WOCA.
Ocala. Damage control. Damage control. Damage control. Damage control.
All right, 25 minutes before 11 o'clock. Thank you for tuning in. Wednesday morning. Looks like it might want... Oh, it looks like it is raining out there right now. John Fuller is here to answer your legal questions. John is an attorney at the law firm of Fuller & Fuller here in Ocala. This show is called Legally Yours, and today's date is November 20th, 2013. You are being informed of the date, so you know whether this is a live show or not. It's November 20th. If it's that same date on your calendar right now, then you are listening to a live show, and you're invited to call in with your questions. The number is the WOCA Climate Control Source Hotline, 622-9622-622-WOCA. Good morning, John Fuller. How you doing?
Good morning, Larry, and I hope all of our listeners are doing well, and we'll have a very happy, safe Thanksgiving holiday next week. We will not be here live next week, but we're happy to be here today. And if any of our listeners are confronting a potential legal problem, if they've been in an automobile accident or they were injured in some other fashion, they have questions, we're happy to talk in general terms. You never appreciate good health until you see someone who's been in a really bad automobile wreck and are having significant problems. It makes you appreciate good health. It also reemphasizes the importance of making sure that if you are in an accident, that you take care of your legal rights. You do all the things. One of the little tidbits that I think is important is if a person is injured and seeks medical treatment, that they are very thorough in being a good historian. And
Yes.
don't try to make things worse than they are or be a malingerer or anything like that. But also don't try to be a Superman who denies pain or loss of motion or limitation. You just need to be absolutely candid and make certain that, and if you need to, write a little note down before you go to see your physician, because doctors are busy, and with electronic medical records now, it can be sometimes onerous to enter all of the information, and it needs to be documented what your complaints are, what your symptoms are. And while a lot of it is objective and self-evident, if you have a compound fracture of the femur, any layperson can see that on an x-ray, but you need to be very, very thorough. And if you need to write down, I couldn't get out of bed Wednesday because I had a flare-up with my herniated disc.
Right. Yeah, I think you're right. Write it down, journalize everything. And you ready for the phone calls?
Absolutely.
All right,
I'm delighted to have people call.
Just real quick before we go to the first phone call, everybody's invited to call if you would like. The number is 622-9622. Did they bail out? Good morning. You're on the air with John. Yeah, I think they bailed out.
Hello, sorry.
Yeah.
I appreciate you calling, and if you call back, we promise we'll take you straight away.
Yeah, well, that's what happens. And that is what happens. Just for those of you who are not familiar with how we conduct the show, if you call, I will push the button that answers the phone, but nobody will say hello. Just kind of wait until John takes a breath, and then he'll come to you, just so you know.
Okay.
There is nobody saying hello. No call screeners here.
Okay. Well, we are always appreciative. We have some wonderful listeners who have really contributed a lot to this show by their observations and their questions, and we appreciate that. The PIP law that we've talked about, the personal injury protection law that has deprived a lot of people of their PIP coverage that went into effect a little over a year ago, has had its first appellate hearing, and the District Court of Appeals that heard it didn't rule on the issue of constitutionality. They sidestepped that on what is called a standing argument by saying that the plaintiff that brought the issue to the court did not have standing to speak for the injured party, in that case. So we still don't have a definitive answer. There are other cases pending, and ultimately a court will decide it, and as soon as one of our intermediate appellate courts decide it, then I'm sure it will end up in the Florida Supreme Court as a question of great public importance.
Have you ever had somebody come to you, they felt like they were done wrong by somebody else, and they want to sue them? And you say, maybe it's just a matter of getting with them and talking. Do you ever talk somebody out of a lawsuit?
Oh, absolutely. I think that's, a lawyer's role is to make certain that that it's not a frivolous lawsuit, that it's a meritorious lawsuit. And there's sanctions. There's provisions in the statute that if someone brings a lawsuit that is completely devoid of merit, now I'm not talking about you bring a lawsuit and you lose it, that doesn't trigger it. But if it's a frivolous lawsuit, then you can end up being responsible for attorney's fees. Let's take a call before I lose somebody.
Good morning, you're on the air.
Oh, you'll never lose me. I just love your program.
Oh, thank you. How are you, sir? It's always great to hear from you.
Thank you very much. Doing fine, and thank you. A thought just came to my mind here this morning. I want to call in and ask, are lawyers, do they have to go on jury duty like everybody else?
Yes, they are not automatically exempt.
Okay.
And I have actually served on a jury a number of years ago. The courts, as I have told people who call in about jury duty, my experience has been that if you have a legitimate reason as to why you can't serve at the date that you are summoned for jury duty, the judges are usually very, very helpful in saying, okay, you have a previously planned vacation that you've booked and paid for and you can't get your money back. We will reschedule your jury service to next month. And so jury service is just an absolutely essential component of our judicial system. We all want to have a forum where our grievances can be heard and decided fairly based upon the law and the evidence that is admissible, and by open-minded people who bring no preconceived biases or prejudices that might affect their judgment on that case. The jury system is a wonderful thing. It is something that needs to be zealously guarded, and one of the ways that it works is for people from all walks of life to serve on juries.
Right.
And I found it when I served, even though I had been practicing law probably 10 or 12 years at that time when I was summoned, I found it to be a very interesting experience. I learned a lot. It was seeing the system from a wholly new perspective. I had already tried 50 or 60 cases at that point, and never really appreciated the dynamics of what went on in the jury room. And so I encourage everybody to serve.
Yeah, it would seem to me that it would be quite an advantage in certain cases to have a practicing lawyer on a jury for one side of the case, maybe not so much for the other. Is it ever a situation where somebody would fight the fact that because you're a lawyer and you're on a jury, it wouldn't be fair and they could have you dismissed or removed?
I would personally be very reluctant to have a lawyer serve on a jury in a case that I was trying. I was very surprised that the lawyers in that case allowed me to serve. It's not that you're not doing the best job that you can, but we are all a product of our education, background, environment, training, and so forth. And the jury needs to decide the case upon the legal instructions that are given to it by the judge.
Right.
And my fear would be that inadvertently, if there's a lawyer on the jury, he may, if he says what his opinion is, his or her opinion, that may and somehow overly influence the other jurors. So I personally would be very, very reluctant, and you don't see many lawyers serving. I know several who have. And it just depends on the nature of the case. If it really, it's, you want a juror that is fair and unbiased, because only fair jurors that are not biased by prejudice or pre-existing thoughts can dispense justice. And that's what we all look for when we go to court.
Would there ever be a situation where, like, a judge would have to be on the jury duty?
No, I don't believe so. I haven't checked the statute on that, but I don't think judges I think they are exempt. So I don't believe that would ever happen. But certainly lawyers can and do serve. And I, when I was on the jury, I made it a very, very emphatic point that I would not express any view of any of the elements of the charge until everybody else that was on the jury had expressed themselves and had made their statements as to what their preliminary opinions were and what have you. And then after they had everybody in the room had their say, then if I felt differently or if I felt I needed to comment, I did. But, you don't see it happen often, because with people who work in the system, you're a product of your environment. And even though you have an open mind, you still bring to it your own background information. And that's why there's not a quote right juror or a wrong juror. Some people would be great jurors for a certain case and not a great juror for another case. If you are called to serve on a jury in an eminent domain case where a governmental entity is condemning property for a road or a bridge or something like that, and you're called to jury duty, and you have no background information or interest or knowledge of specific nature about that, that's a great thing. And you would probably be a wonderful juror. If you were called to serve on a jury, and I don't mean you personally, but an individual was called to serve on a jury, and it involved the accident case, and that individual prospective juror had just lost a loved one in an accident case 6 months ago, that's not someone who you want to sit on your jury, because they are so overwhelmed by their own personal experiences that they cannot. It's just, I think, a human impossibility. They could be a perfect juror in the eminent domain case, but if they have been or if they've been a victim of a criminal offense, and you're called on to be a juror in a criminal case, you may not have the same objectivity as you would. So one person would be a great juror for one type of case, but would be unsuited for another type of case.
Okay, well, another great answer to another great question.
Well, thank you.
On a very great program. Thank you very much.
Well,
I really enjoy it, and I always look forward to talking to you.
Well, you're very gracious, and I certainly want to reiterate my appreciation for your interest in taking the time to call in. Your questions are always very, very enlightening and gives us a sense of what people are wanting to hear, because we want to help.
You have a great holiday, and I'll look forward to a very good year coming up next year with a lot of good questions and answers. Okay?
Thank you very much, and good happy holidays to you and your family.
And John, you have another phone call. Good morning. You're on the air with John.
Good morning.
Good morning.
Hey.
First of all, I'd like to wish Mr. Fuller and his wife and the family a very happy Thanksgiving.
Thank you so much.
And it's always...
Hello?
You there?
Hello?
Uh-oh.
I don't know,
we
but
lost you. Lenny, we lost you.
Leonard, you just got cut off, and I promise you, I didn't touch anything or do anything, so don't blame me. Hopefully, you are hearing this, and we'll call back.
Okay.
Oh, there he is. Okay.
Okay, yeah, we lost you there for a minute. Yes, can you hear me okay?
Yeah, I can hear you. All
Good.
right.
Well,
You all fine.
I appreciate you calling. I hope you and your family have a very wonderful Thanksgiving and holiday season, too.
Okay. Can you still hear me?
Yes. Mhm.
Okay. This question kind of is a different question. I was just watching this trial with, the little hearing that the congressman from down in Fort Myers and Naples had, where he was caught with possession of the cocaine, and it's funny how now he's going to be on probation, but they've got him taking counseling in Washington, and he's supposed to go in a rehab center down in his district, District 19 in Naples. My question is, how do you do that? And also, because he has a 2-year-old child, does children and family get involved in that in this state? It seemed it was kind of a rather complicated case. I'll hang up and listen to your answer.
Okay. Thank you again for calling. I do not know any specific details about that case. Generally speaking, if a person is a candidate for probation, the probation has to be served in the area where they live or the offense was committed. However, they can make allowances that if you live somewhere else, they will transfer your probation to a probation office where it's somewhere else. As far as DCF getting involved, there would have to be some probable cause, I think, that would show that this gentleman or lady, whoever it is, constituted a potential danger to the 2-year-old. And that's really about all that I can offer on that. Sometimes the probation people and the courts will grant permission if a person has a drug problem and is going to be an inpatient in a rehabilitation facility. Some very fine ones, Hazleton, Betty Ford, some of those are all out of state, but they are allowed to go in as long as they're inpatient and not allowed just to go and come as they will. And then after that, they have to return to the place where their probation is being served, and they require random drug screens. They have to report to their probation officer. They have to continue with a very rigorous aftercare program of counseling, and that's how it's normally handled, especially if it's a first offense.
Okay.
So hope that answered your question.
And I think you have another phone call on here. Good morning. You're on the air with John Fuller.
Good morning.
Good morning, Mr. Fuller. I was on a jury once and managed to go through the whole deal, the case and everything. And we went to deliberate. You know, they finished up, and we went to deliberation. And while in deliberation, it seems that the plaintiff decided to settle.
Right.
And what was really odd about it was we were deciding, whether he had a case or not, and we were 100% for him. All the jurors thought the same thing, that he was damaged and he deserved an award and everything else. And we found out later on that he settled. It was for what he settled was a waste of his time and money to hire a lawyer to go represent him in court against the manufacturer. And I was just wondering, sometimes it doesn't seem that there's any justice, and I was just wondering if you had any experiences like that. And I'll hang up and listen. Thank you.
Thank you for calling. I've had numerous experiences in cases like that. First of all, no lawyer has a crystal ball, and no lawyer can predict what a jury will do. So the lawyers may have tried the best case possible, but there is always a risk, and it's no one can predict what a jury will do. Also, you oftentimes will see defendants refuse to offer any money at all until you start the trial process. I don't know what motivated the settlement, but when you settle a case, you have closure and finality, and by that I mean neither party can take an appeal. You may have been impressed and convinced that the plaintiff in that case was injured by the negligence of another party and suffered damages as a result of it, and that those damages merited substantial award of money. The plaintiff and the lawyer have no way of knowing that during the trial or deliberation. So it may very well be that they took a settlement. It may well have been that the settlement that they took constituted all of the insurance coverage that the defendant had, and there were no other assets that they could recover. And so you would then take what the maximum liability payment would be, assuming it was offered during the trial or during deliberation, and you would be better off than rolling the dice and maybe getting an adverse verdict. Also, there may have been in one of the other lawyers' mind that there may have been some type of potential reversible error, so that even if it resulted in a good verdict and judgment, that it would be appealed to the appellate court, and that would delay getting the money and run the risk of a reversal where you would have to come back and try it all over again. So I've had cases that I have tried for a long period of time, and during the trial process, negotiations were going on.
Oh, really?
And while the jury was out, we have settled it. Sometimes you know what the jury, so if the jury hadn't reached a verdict, you don't know what they were doing, and the mere fact that everybody was thinking one way at one time doesn't necessarily mean that would end up in a verdict. But I've had cases that have gone both ways. I've had cases where I have settled them, and afterwards, jurors voluntarily made statements. You can't go interview a juror without a court order, but jurors voluntarily made statements that we were not impressed by the plaintiff, and we were very likely not going to award any money, and we had negotiated a very good settlement. I have had other cases where we tried the case, felt very good about it, while the jury was out, settled the case for a substantial amount, and the jury, while they were out, the settlement was consummated, and about that time the foreman knocked on the door and said they had a verdict. And the judge, once the settlement was binding, and the jury came back and said, we don't find for the plaintiff. We think they should get zero damages.
Oh, wow.
So you always feel like you kind of dodge a bullet with that.
Yeah.
Most of the cases that we see, I think jurors do a very good job of ferreting out the facts, the liability issues, and the amount of damages. But again, there is no certainty in a jury trial. There is no guarantee, and anybody who tells you he can predict what a jury is going to do is not being honest, ethical, and candid with you, because it's impossible.
Oh, wow. So the only binding thing is what happens first. If
you have a settlement that is agreed, announced, done, and then the jury comes back, the settlement is still binding.
Oh, wow.
Okay, and that's for good or ill. And like in the case this gentleman just talked about, when they later found out. Now, a lot of settlements are confidential, and the amount of the settlement is never made public by agreement between the parties, and there's no way. It's very surprising that a settlement would be made known. The amount of the settlement would be made known, because I have never had a case where the defendant paid money that they didn't insist upon a confidentiality, that you not disclose what the terms of the settlement were.
Wow, that's pretty fascinating. I never even realized that could happen. that you can actually, before the jury comes back, make an agreement.
Until the jury comes in and the jury foreman announces the verdict, it's still in the hands of the parties. Yes, sir.
Yeah, it looks like we can squeeze in one more. Good morning. You're on the air with John.
Good morning.
Good morning, Mr. Post. Sonny calling back. The fact is, we were still in the sequestered when the judge came in to tell us this.
Yep.
And
happens frequently.
He asked us what we thought. After we told him we would have decided for the plaintiff, he asked us what we thought the settlement was, and he says, "Oh boy." He should have waited for you guys.
Right.
That's
Well,
what I mean that the settlement we would have picked would have been greater. I'm just assuming that. He didn't tell us.
I understand. That comes under the category of 20/20 hindsight.
Yeah.
It sure does.
I think most of us on that jury were really disappointed that the way it worked out. But I guess
you shouldn't be disappointed. You shouldn't be disappointed because your participation in the process facilitated its resolution. For good or bad, those parties couldn't settle that before starting trial. Those parties couldn't reach an agreement until they had gone through the case, and neither party wanted to take the chance or the risk of an adverse verdict, so they reached a compromise that they deemed satisfactory, and they were unable to do that until you served on a jury, and for that you should be commended.
Well, anyway, that's the way we all felt about it. Thank you, and have a great day, and thank you for your time and your programming and talking.
Thank you very much, and thank you for calling in and listening.
All right. Well, good show today. Went so quick, too.
Yeah. Are we done?
Good conversation. Yes, sir.
I always enjoy. We have wonderful listeners and wonderful questions, and it's a joy to chat with them.
So before we say goodbye, we won't see you next week, so have a great Thanksgiving.
Thank you. You too, Larry. Hope you and your family are all well and enjoy the day, and hope all our listeners have a very happy Thanksgiving.
And one quick more question. What's your phone number?
The office number is 352-547-4292. Our toll-free number is 855-534-2565. We have offices in Ocala and the Villages. If you are injured or you have a legal issue that you care to talk about personally, please call.
All right. Thank you, John.
Thank you, Larry.
We will take a little break, and we'll be right back.
Ocala's information station, 1370 WOCA.